I'm highly disturbed. I am highly disturbed in view of the judgment given by the Upper Sharia Court in Kano, sitting at Hausawa on the 10th day of August 2020 in charge number CRO/43/2020 in the case of the Commissioner of Police and Sharif Yahaya. In the case, Sharif Yahaya was convicted for blaspheming under the Sharia law, penal code of Kano State. And I dare say here that that decision is illegal, unlawful, and unconstitutional. Why do I say that? I'm not speaking from the air. I'm not floating. I'm saying that based on the Constitution. No sentiments, no religious attachment, no tribal attachment. I'm speaking from the provisions of the Constitution of the Federal Republic of Nigeria, which is the ground norm, the highest law of the land. Section 1 of the 1999 Constitution states that the Constitution is the supreme and the Constitution is supreme, and its provisions shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria. Section 2 of the Constitution also goes further to state that the Federal Republic of Nigeria shall not be governed, nor shall any person or group of persons take control of the government of Nigeria or any part thereof except in accordance with the provisions of the Constitution. Now, these two sections goes to establish the supremacy of the Constitution. Having said that, we want to look at under what law was this man convicted. He was convicted under the Sharia, under the penal code. Now, if you look at that law, vis-a-vis Section 10 of the Constitution of the Federal Republic of Nigeria, you will agree with me that it is unlawful. Section 10 of the 1999 Constitution provides that the government of the Federation or of a state shall not adopt any religion as state religion. Now, from all indications, it is clear that Kano State had adopted or has adopted Islam as a state religion, which is against Section 10 of the Constitution. So now, just opposing Section 10 of the Constitution and the Sharia law of Kano State, under which Sharif Yahaya was convicted, you will agree with me that there is conflict. And as usual, the Constitution has provided for where there is a conflict between the Constitution and any other law. And that provision is none other than Section 1, Sub 3 of the 1999 Constitution. And that provision states thus: if any other law is inconsistent with the provisions of the Constitution, this Constitution shall prevail, and that other law shall to the extent of the inconsistency be void. So, in the circumstance, it is my humble view and submission that the Sharia, the penal code, or the Sharia law under which the Yahaya was convicted is in conflict with Section 10, and therefore it is void. Now, you may want to say that, after all, Section 36, sub 12 of the Constitution is in support of the conviction of Yahaya. That Section 36, sub 12 states as follows: subject as otherwise provided by this Constitution, a person shall not be convicted of a criminal offense unless that offense is defined and the penalty, therefore, is prescribed in a written law. And in this subsection, a written law referred to an act of the National Assembly or a law of a state and subsidiary legislation or instrument under the provisions of a law. Now, if you look at this provision, it will only apply if and only if that state law is not in conflict with the Constitution. But as long as that state law, the Sharia law, under which Yahaya is convicted, is in conflict with the Constitution, it will not stand. It will only stand if it is in harmony, if it's harmonious with the Constitution. Then you can say it can stand. Now, going further, I would want us to take note, and strongly too, that by virtue of Section 33, sub 1 of the 1999 Constitution, Yahaya has a right to life, which must not be tampered with by the governor or any person. The provision reads thus: every person has a right to life, and no one shall be deprived intentionally of his life, save in the execution of the sentence of a court in respect of a criminal offense of which he has been found guilty of in Nigeria. Now the question is, the law under which he was found guilty, is that law in conflict with the Constitution? If it is in conflict with the Constitution, then it is not an authentic judgment, or will I say it's unlawful. The judgment is defective. The judgment is wrong and must be set aside on appeal. But if the law under which Yahaya was charged is not in conflict with the provisions of Section 10, then we can say it will be right for those agitating for the governor to sign the execution of the judgment, the death penalty on Yahaya. We can say that they are right, but if not, then they are wrong. Nigerians, it is high time we start looking at the Constitution. We should stop doing things from our head or our whims and caprices, or at the spur of the moment, or based on religion, tribal sentiment. It's a shame that at this point in time of our development, we are behaving in a very disgusting and arbitrary way that does not portend or shows us to be civilized.